All right. All right. Hello and welcome. Hello and welcome. Thank you so much for being here and welcome to another episode of the Empowered Immigrant Live. My name is Otis Landerholm, and I'm grateful to be here with each of you. I'm the founding attorney here at Landerholm Immigration A.P.C, where we fight for your American dream. And boy, is it a fight right now. It is crazy, folks. Everything that is happening in the world of immigration law. And thank you so much for being here. And thank you for taking a brief moment out of your day to stay educated, stay informed, stay engaged about all the different changes that are happening. Today on the Empowered Immigrant Live, I want to talk about what the Big Beautiful Bill Act really means for immigration. Okay? And so thank you for being here. It is the 8th of July of 2025 is when I'm filming this. And so if you're here with me live right now, whether you're on YouTube, LinkedIn, Facebook, Instagram, TikTok, like hello, welcome. Thank you so much for being here. Really appreciate each of you. Okay? Remember, the Empowered Immigrant Live is here to train, teach, inspire, and empower immigrants to make the most out of immigration laws and to make the most out of their lives. All right? Today, our theme is, what does the quote-unquote Big Beautiful Bill Act, what does that mean for immigration? What does it really mean for immigration? And my question, as I always ask, is, hey, do you want to apply for a green card or asylum or a U visa or VAWA or citizenship? Or do you want to figure out what your best solution is, what your best strategy is to improve your life through this immigration law maze that keeps getting more and more complicated, right, as we go forward? Because if you want help navigating that maze in any way, hey, I'd love to help you. My firm is on a mission to win 10,000 cases in the next 10 years. And yes, we are winning cases even right now, even during the Trump administration. And if you are interested in working with our firm, we would love for your case to be one of our 10,000 wins that we're going for by 2035. And so if we can help you with that, these are long cases, these are big cases, these are challenging cases, and it's ever more challenging. And I'd love to help you navigate this as best as we can, and we are doing that, all right? And so we're here to help. We'd love to help. If we can help you, feel free to reach out. So lots of things have changed. You've been seeing the news. You know, Trump has been back in power since January. We're now a little over 6 months into his second presidency. And there's been so many changes. The change I want to talk about right now was signed into law last week. It was signed into law on July 4th by the president. It passed both sides of Congress, so this is actually law. The reconciliation bill, the One Big Beautiful Bill Act, so to speak. It's a very ugly bill when we discuss immigration, right? Well, I'm not talking about the tax implications. I'm not talking about people losing Medicaid in the future. I'm not talking about raising the debt ceiling, right? There's implications to all of those things as well. But for today's purpose, I want to talk about what does that act really mean for immigration, all right? Basically, to give it to you straight, it means two big things, all right? One, it means enforcement, immigration enforcement, ICE and Border Patrol are going to have a lot more money, and we'll discuss what that will do. And two, it's also in the bill that there will be increased fees for certain things for immigrants. All right? The bigger of those things is the first thing. All right? So to give you an idea, Congress is giving Trump the money that he wanted to increase deportations. All right? $45 billion going into immigration enforcement, building the wall, all right? Giving ICE the resources it needs to build additional detention facilities, doubling the capacity to detain immigrants, doubling the bed space for immigrant detainees in immigration detention. All right? That those changes won't go into effect overnight, right? It takes a moment for them to be able to build detention facilities and hire ICE officials and train them and weaponize them. But those are going to happen. All right? The Congress has now given the government the resources to do that. It will increase the number of immigrants that are detained every day, right? It might double that amount. It might more than double that amount. And so we've got to be aware of that, and we've got to be ready to fight against that, okay? They've also allocated $3 billion to hiring new immigration judges. They know that there's a serious backlog. It's kind of crazy because they've actually fired some immigration judges just earlier this year. So fire what in their view are the bad judges, what in my view are the good judges, and they'll hire some new Trump appointees to be immigration judges, which that's going to happen, folks. It is going to happen, which means that we've got to fight all the more each of our battles in immigration court, and we've got to bring it, right? We've got to bring it, and we've got to step up our game in the immigration courtroom, and that is happening. All right, the second thing that I mentioned is an increase in fees, and this is the lesser of the two evils, right? But it is, there are fees that are going up. And, they're charging a fee for the first time ever on applications for asylum. And it's written in the code as it's $100 fee for asylum that's imposed each year. All right, I'm not actually clear as to whether or not that annualized fee will happen, because it's not super clear if that was in the final version, the final text of the bill. But as I read it, yes, it's a $100 fee to apply for asylum and a $100 fee each year that your asylum case remains pending. All right? I'll add something to the description of this video if for whatever reason that's inaccurate. But as I read it right now, that is in what I am reading. There are also fees for work permits through asylum, $550 for the work permit. The fee to appeal a denial of a denied asylum case is now $900 for the appeal. That's up from $110 to $900. All right, that's going to reduce and make it much more difficult for people to appeal if their case was denied originally. All right. And there's other fees for special immigrant juvenile applications, fees for parole applications, fees for TPS applications, and more, okay? And so you're going to need to be aware of this. If you're applying for whatever you're applying for, obviously talk it through with your lawyers as to what the precise fee is on your application, but you got to be aware that these things are happening, okay? And so that's what I wanted to share today. Compressed a lot of news and information into a very short soundbite there. And I do have some time, right? There's a lot of folks that are present with me here on YouTube, Facebook, LinkedIn, Instagram, TikTok. I don't have a lot of time, all right? We've got a lot of, we're filing an appeal later today, and just checking at the filing fees, it already has gone up to this new $900 filing fee, right? And so we've got to get that on file and deal with that. But I do want to give some time to each of you to ask a question if you have one. I'll have time to answer, I'll say 7 questions right now, and I'll do my best. Right now I see 1. And if there are more, feel free to submit additional questions. And if we just have 1, hey, then we'll wrap up early. But thank you all again so much for being here. Again, my name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C., where we fight for your American dream. And thank you for being here. So Coyotita75, I see your question here. You say, if my daughter-in-law got deported and they banned her for 10 years, does she have to wait the 10 years? Okay, this is a great question. This is a great question. Thank you for asking this. The 10-year bar sometimes can be waived. All right, sometimes it can be waived. So waivers are going to be very important in this environment, right? Waivers are going to be important solutions in some cases. When a person is literally deported, they trigger two inadmissibility grounds, all right? And sometimes more than that. One is Section 212A9A, which creates an inadmissibility for 10 years if someone's deported by an immigration judge. It's a 5-year bar if someone's deported expeditiously. So if someone's expeditedly removed and never got to see an immigration judge, they'll have a 5-year bar. Okay? So that's 212A9A. And then 212A9B creates the 10-year bar. And that is for unlawful presence. If someone has more than 1 year, more than 365 days of unlawful presence in the United States at the time that they leave, whether it's through a deportation or not, right? If they just leave after having more than 1 year of unlawful presence, they trigger that 10-year bar, all right? Both of those things are waivable. The deportation bar is waivable on what we call the I-212 waiver, and the 10-year bar, 212A9BII, is waivable on Form I-601. And but the question is, for the 10-year bar, is a person would need a qualifying relative, and that is either a U.S. citizen or green card holding spouse, or a U.S. citizen and green card holding parent who would suffer what they would call an extreme hardship if the case were denied. If you have those things, then your daughter-in-law, even if she were deported, could, in theory, waive that deportation and then re-enter the U.S. lawfully if someone could petition her. Okay? All right. Thank you for asking that question. Maria Lacerda, I see your question. Do you know if the big, beautiful bill is going to target people who applied for the U visa? All right. As I read it right now, no. All right. It is not directly targeting or focusing on the U visa. And U visas are still good solutions. And they are very, very slow, though. And so immigration enforcement can still happen against a person even with a U visa pending. All right? And so that's something that needs to be clarified for some people. Some people didn't get that explanation. You apply for a U visa, it's pending for years and years and years. Just because you have a U visa pending does not give you protection from ICE necessarily during that time that it's pending. All right, once you're granted what we call deferred action, I mean, that's something that says, hey, you've been granted deferred action. We're not clear whether or not that's going to, or how long that's going to continue for. Right now, I haven't seen any announcements saying that they're taking away deferred action for U visa holders. Okay, so that's that. Paleman 100, I see your question here. You say, I am a naturalized U.S. citizen. Am I safe, or can the government cancel it? Okay, good question, good question. So there is a way, and the government is announcing that they want to denaturalize certain people. But what they're talking about is if a person lied to get citizenship, if there was fraud in the citizenship application. The most common scenario there is if a person had a crime, a criminal record, and then they did not say that they had that crime at the time that they applied for citizenship. All right? If a person is in that situation, the best advice is talk to a lawyer and get really clear on the records, request all the records, make sure that you are ready, right? And make sure that you're aware on what your game plan would be if you were ever put into denaturalization proceedings. All right, but Paleman 100, if you are a naturalized U.S. citizen and you were 100% honest and your green card was valid and you were 100% eligible for your citizenship, then no, you're okay. All right, you have won your case. All right. And if you have questions or doubts about that, hey, feel free to contact our office. We could request all of those records for you, do a detailed analysis, and help bring clarity to that. Okay. XOXO, I see your question. You say, what about VAWA? Is immigration attacking it too? Good question. You know, I don't see anything in the big, beautiful bill, quote unquote, which actually is very ugly if you ask for my opinion about it. It's a big, ugly bill. All right, but it has passed. I don't see anything in it that directly attacks VAWA, okay? And if somebody has applied for VAWA, there's a question as to, did you apply for VAWA as an adjustment of status, or did you apply to VAWA just as the petition? The petition by itself does not give you protection from ICE, right? So a person could still be put into immigration court proceedings, right? And actually, if you apply for VAWA as a one-step adjustment of status, if you win a green card, great. But if you lose that case, you could be put into immigration court proceedings too. But, you know, VAWA can be fought about in immigration court. And so that's something to be aware of also. We have something called VAWA cancellation of removal that can allow people to get green cards in certain situations if they've been the victims of abuse by a U.S. citizen spouse or parent in some instances, or a green card holding spouse or parent. Okay, and so that's that. All right, Amor Agape, I see your question here. You say, is it true that a post-conviction relief is always visible to USCIS and any federal agency? That's an interesting one. So what is true is that even after post-conviction relief, USCIS and the federal agencies will still see the conviction that had happened in your record, all right? And so they will still ask questions about it, right? And so it doesn't automatically undo the fact that you were arrested or convicted originally, but then you can show the post-conviction relief, and if it was a quote-unquote vacatur, where it was vacated on legal grounds, then that conviction should no longer hold the legal ramifications of the quote-unquote conviction. Okay, that can get a little bit tricky. And so, Amor Agape, if you are thinking of filing for something, but you have won post-conviction relief of a criminal matter, the best advice is talk it through and have an immigration lawyer who really knows what they're doing help you with your immigration process so that when USCIS sees it, right, or when the immigration judge sees it, they understand that your case is still approvable despite that conviction that happened because that conviction has been vacated. Okay? As long as that's the reality. Okay, so anyway, hope that's helpful. Anas, I see your question, and then DJEFLY45, I see your question. You're my last two questions for the day, and then I've got to get to it, okay? So Anas, you say, I'm married in May 16th to a U.S. citizen. Hey, congratulations, all right? Congratulations, you're a newlywed. All right, you got approved for an I-130. That's a very fast turnaround on an I-130. Do you mean May 16th of this year? That would be a record time for sure to get an approved I-130. Should I file my I-485 or wait? Okay, that is a question involving legal advice. Do a consultation. All right, do a consultation with an attorney. If you are admissible, if you're eligible for the I-485, if you have no issues in the past, then yes, you should absolutely file your I-485. But if there's a risk, if there's a red flag, if there's a challenge in your case, talk it through with an expert who can guide you through that challenge and who can help you navigate this process. Because adjustments of status, I-485s right now have risk, right? If you file and if you lose, they're going to put you into deportation proceedings. And so you want to make sure that you're going to win that thing. Okay? Last question of the day, DJE Fly 45. You say, I didn't disclose a dismissed arrest on the N400. I came clean with court evidence at the interview. Can it be revoked? You didn't disclose a dismissed arrest on your N-400. It came clean with court evidence at the interview. Can it be revoked? I mean, they could try, right? They could try. Anytime you were arrested, but you said, no, I have never been arrested, then that's potential. Like they could allege that was a willful misrepresentation on your N-400. And whether or not they find that, whether or not they know that, whether or not, if it really was, if it came clean, it's like they could denaturalize you, but they couldn't deport you about it because it was dismissed anyway, right? So if they denatched you, they would give you your green card back, and they wouldn't deport you. They'd give you your green card back, unless it really was, like if they found that it was fraud, like intentional fraud, then okay, they could put you in deportation proceedings for that, and then you could still file for cancellation of removal, right? So there's lots of things that you could do there. It sounds like I don't think you're at much risk. I don't think you're at much risk, but based on what I'm hearing right now. But is there a slight possibility that they could, argue that there was a willful misrepresentation of a material fact on your citizenship application? It's possible. All right. Anna, I see your question here. You have a pending asylum case since 2023. I got that. JAL, where are you located? We're located in Oakland, California, and we help clients, and we have clients throughout the United States, but we are here in the beautiful city of Oakland, California, and we fight for the rights of immigrants. All right? And I see DJ eFly45, I see your follow-up. During the interview, you brought the evidence and you were granted citizenship. So yeah, if you gave them the evidence and clarified that issue during your interview, it's a non-issue. All right, even if the form said one thing originally, but then you clarified that and you brought the evidence during your interview, then that's great. You should be fine. Rest assured, right? All right, you all. Thank you so much for being here. I really appreciate your tuning in today. Sorry that I'm quick. All right, sorry I'm keeping it short, but there are a lot of demands, as you might imagine, on my time right now. If any immigration lawyers are listening to me right now, I'm hiring 3 lawyers simultaneously right now. So if there's great immigration attorneys, or if you know a great immigration attorney, please feel free to have them contact my office. We are hiring, and we need the support because we've got a lot of cases and there's just so much change happening. It's like we got to be ready to fight that fight. All right, so good immigration lawyers wanted. And if you have an immigration case and if you are looking for help with your process, right now, like as of today's date, my calendar is 1 month out, right? So we are packed. And if you want to get in, or if you want to book that next consult, hey, feel free, give us a call. We're here to help. We'd love to help. And thank you all so much for being here. Again, my name is Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C., where we fight for your American dream. And we'll see you next time, all right? We'll see you next time on our next episode of the Empowered Immigrant Live. Thanks a lot. Make it a great day. Take care. Bye-bye.